Thank you, Andrew. After Catherine's extremely informative talk and these essential notes, I'm very conscious that what I'm going to say is probably not going to tell any of you anything that you don't already know, and involves very little actual law. I'm going to be talking about relocation, those cases where a parent wants to move permanently with a child to a different country. I'm definitely not going to be giving you the case law on relocation, so I hope you haven't come for that, but looking at this audience, I suspect you know what you're doing in those cases and don't need any of that anyway. What I'd like to do is to start a conversation about whether we could or should be approaching relocation cases in a slightly different way. So, I'll explain what I mean. I've been instructed to attend many first hearings for Hudras in international relocation cases. And over the years, I've picked up that they've got a few things in common. The hearing is generally pretty short. Often you have an agreed order and you're back in chambers by 10:30. Often, relative to other cases, the hearing is happening quite shortly, maybe just a few months after the separation. The parties probably won't have been to mediation, even if one or both has done a MIAM. And at some point, someone, often it's me, will use the word binary. Now, that is because the received wisdom in these cases is that these are cases where there are only two possible outcomes, 1, 2. Therefore, the thinking goes, there is no possibility of compromise. And in a sense, that's true, because if parent A has her heart set on going to Australia and with the children, and parent B is absolutely adamant that the children are best off in London, the midway is not Hong Kong. There is no possible compromise in that sense. But what I'm going to be saying this evening is that we need to be a bit cautious about approaching every relocation case that walks through the door in that way, as if there are only two outcomes and we are going hell for leather for whichever it is that our client is proposing. Now, just to be clear, I'm not talking about what you do once you're in litigation. Once you are in the court process, and by that I mean in any document that might ever make its way anywhere near a judge, so correspondence, the lot, you are, of course, not going to be presenting your client's case in an equivocal way. So for the relocating parent, this is the case that you're presenting. And for the parent left behind, that's the case that you're presenting. I'm not saying that there is really much scope for doing anything different. And that's how it's going to look to the judge, who may or may not accept the cases as they are being put, but at that stage, at final hearing stage, really is making a binary decision, that one or that one. What I'm talking about is the period leading up to the litigation, and even during the litigation itself, what's going on behind the scenes between you and your client and between the legal team on the other side and their client. What is the reality in relocation cases? The answer to that is we don't really know. They are more than almost any other case, a giant leap into the unknown. Is it happy ever after for the parents and the children who relocate, or is it a rather more bleak picture? There has been along the way some research, and Alison Chalby from Reunite was telling me this evening that they have some more research in the pipeline. You'll probably know about Dr. Madeleine Freeman's paper in 2009, and Rob George did a review of court files and relocation cases in 2012. That research so far has presented a mixed picture. It is, of course, based on quite a limited sample, because we don't routinely follow the outcomes of these cases after the order is made or refused. So the research that is done is based on interviews with those parents who are still around, still contactable, still willing to speak. And of course, it had to be acknowledged that quite often the parent who wants to speak to the researcher is probably the parent who is more dissatisfied with the decision. But what comes out tentatively from that research is that, firstly, the often problems in maintaining contact after a relocation takes place, and a dissonance between what is presented as a contact plan and what actually happened. And also the mixed feelings of parents after orders have been granted or refused, in contrast to the binary cases put before the court. I will be absolutely devastated either way. So I picked up something interesting that was said by one of the mothers interviewed by Madeleine Reardon, who'd been granted permission to relocate and then regretted it. And she said that she wished that instead of the assumption being happy mother leads to happy child, someone had looked at it the other way around and said, well, shouldn't it be happy child makes happy mother? And what she was saying was that after her relocation she was stuck with a pretty miserable child, and that wasn't good for either of them. So it gives a lot to think about, the research that's been done. We don't have a comprehensive understanding of outcomes. As practitioners, we often don't find out what happens after our own cases conclude, but sometimes we do, and I thought I'd share a few from my experience. To avoid identifying anything accidentally, I've changed some of the countries, and I'm sure I've been against some of you in some of these. So if you think you recognise it, you might just, don't go sharing what you think you might have picked up. So Riem, Canadian mother, British father, family living in the UK for a long time. Mother wants to relocate with the children to Canada. Father wants children to remain in the UK. Outcome application is granted, so off she goes. 6 months later, that was what was happening. So she's homesick for the UK, children missing their father, and mother's desperate to return. Next one, repeat. Mother's Bahraini, father's Dutch. They lived in Holland, and then prior to the hearing in London, which is why I was here. The father wanted to take the children back to Holland. Mother wanted to stay with the children in London. Father's application refused, so outcome, mother to stay with, children to stay with their mother in London, but 6 months later, father's still in Holland, and mother's gone to Bahrain with the children. And what had happened in that case, there was no indication, she was my client, no indication, certainly to me during the proceedings, that she had this in mind, and as far as I know, she was genuine. But afterwards, I don't know what her thinking was, but what I do know is that he just couldn't face or afford another round of litigation, so he really had no option. When she said, I want to go to Bahrain now, he said, okay. Reed J, New Zealander father, American mother, in the UK for about 5 years. Mother wanted to go back to the States with the children, father wanted to remain in London. For various reasons, the final hearing took place, and the outcome was adjourned for a year. Slightly complicated, and I won't go into why, but what happened in the meantime while it was waiting for a rehearing was that mother meets a new partner and then decided to stay. Last one. Parents both British, so unusually an entirely British family. Mother meets a new partner, job in Germany, application to go to Germany, father says stay here, application is granted, as they often are, these ones based on a job. 6 months later, job hasn't worked out, mother, new partner and children all back in the UK, but by that stage, father had thought, oh well, no point me being here if she's going to be in Germany, so he had gone to Dubai. What am I trying to say when I tell you about these cases? It's obviously just anecdotal, but these are some suggestions. One is people's plans and intentions do change. They aren't always fixed, especially perhaps when people are recently separated and struggling with all the emotions that come with that. And things can look really different not that far down the line. The passage of time affects obviously the way people feel, but also stuff happens. People do get jobs, people do meet new partners. That sense of isolation after a breakup may not last as long as the client thinks. The other thing is that, especially in London, people do live quite international lifestyles, so just because they've lived in London for 2 years doesn't mean that either of them are actually going to be here in 2 years' time. So we run these cases on the assumption that where people are at the moment of trial is where they're going to be for the foreseeable future, both emotionally and geographically. And actually, when you look at many families' backgrounds, is it really likely that they're going to settle and stay put? So what I'd like to think about is whether we could be doing more for these parents, instead of launching them straight into the litigation and going down the binary route, to see whether an outcome can be reached which is more likely to be sustainable and which isn't going to see everyone coming back or floating off around the world 6 months later. So this is where mediation comes in. What does it offer? First of all, it's a better way, I think, of reality testing. A mediator can do this in a way that's quite hard for a solicitor to do, especially if you are shortly after a separation, you've got a client who's vulnerable and needing support. It's tricky to ask these sorts of questions of a client who really needs to see you as being 100% on their side. But a mediator can, and a good mediator will do it in a way that keeps the client on side and doesn't make them feel like they're under attack. And a mediator can reality test the other side too. Are you sure you want her to stay? If you have a father who's currently working in London but perhaps hasn't got that many ties, that many roots here, is he really going to stay? If the whole family's American anyway, what are the chances of him going back home at some point in the future, and if he's going to, when might that be? And then the reality testing of the finances as well. It's painstaking work sorting through the costs of a proposed relocation because you're dealing in a different country and you don't have the information to hand. So for a solicitor it is hard, but it's really important it's done. And if you have a client who comes up with costings and the other side challenges them, mediation is actually a pretty good way of getting them to sit down and engage with the other's cases on that issue. And why is it a good idea to do this? Because there's nothing worse than your client ringing up to say how upset she is that you've won her case for her. And you may remember I think I called it the one who went to Canada. She got permission in December, and in January she and the children moved to some godforsaken part of Canada that's basically Alaska, right up the top. And rang up her solicitors to complain that everyone was miserable and it was too cold. And we spent a week, of course, showing the judge pictures of happy children building snowmen. So it really was a case where, during the hearing, she didn't have reality right in front of her like that. She was driven by all kinds of other things, as people often are, all kinds of emotions going on. And something had been missed, I thought, afterwards in the process of preparation for that trial, something that we could have done that we hadn't done, that could have prevented the situation that they all ended up in. So, reality testing is one. What else can mediation offer? Contact logistics. Now, this is obviously a really important aspect of a relocation case, and as the research does tend to show, too often contact arrangements break down after a relocation. It is, I think, almost always a good idea to send them off to mediation to see if they can agree, even on a contingent basis, so that if leave to remove is granted, you've got those arrangements in place. It can also be a good cover if you do suspect your client is a bit wobbly about it all, but they're not prepared to admit that to themselves, let alone to you. Once you've got them in mediation, they may be able to listen to the other side's perspective, and there may be scope for resolution of the whole thing. But even if it really is a head-to-head binary sort of case, the way to put this to clients, I think, is that the court just doesn't have time to deal with the really fine details of flight schedules and contact costs and dates. And often as well, it's left to the end of the trial when everyone is exhausted and highly emotional, and it's a really unpleasant process because nobody's giving an inch. But you can do it in mediation. I did one a few months ago when I was mediating, and we spent 2 full days, 8 hours each day pretty much, sitting around a table. But in the end, they got to an agreement, and I would put money on it actually working out, because during that process it became apparent where the likely pitfalls were going to be, and then they worked out what they were going to do to deal with them. And then thirdly, another advantage of mediating is you can come up with some creative solutions, the kind of thing that a court is never in a million years going to order. Sometimes there is something a bit like a middle way. You can postpone relocation for a couple of years. Courts don't do this because once they've got to the end of a round of litigation, no judge is going to want to leave the door open to another round in a couple of years' time. But if you haven't had that process, if you've avoided litigation and if you've still preserved some trust, then an agreement to a postponed relocation is possible. Unusual contact arrangements. There is a little girl in my daughter's class at school who spends her term times in London with her father, and every holiday from the first day to the last day in South Africa with her mother. Now again, no court will do that, no solicitor will advise that. We all say, oh, you need to share out the fun time, you need to share out the term times, blah, blah, blah. But actually, these parents agreed that when they separated, the mother got a good job in South Africa, they wanted their child educated in England, and actually it works. And then two-country solutions, probably only for those families who are pretty well off. But there are parents who maintain a home in 2 countries and fly in and out. And I had one recently I came across who were doing a fortnightly share in term time. And one parent spent 2 weeks here and 2 weeks in the States. Again, no court's going to order that. All of these things are a bit mad. But if parents agree them and if it works for them, what does that matter? So if you think this might be a case where they might be able to agree something outside the court process that will avoid litigation, why not? Things to watch out for. These are a few perhaps contraindicators for mediating a relocation case. Mediation confidentiality is very hard to preserve in family cases, as I'm sure you know, because people just don't get it, and fair enough. It does lead to a degree of emotional dishonesty, and your client says to you, well, she agreed that she'd stay here and we were pretty much there, and then it fell apart on the division of the holidays, that she was all up for it, and how can she now turn around and say that the prospect of remaining in this country is so horrific she can't contemplate it for a moment? It is very difficult to explain that the mediation process is privileged and protected, but you do need to make sure that clients are fully aware of that, and the circumstances in which it may be waived or breached. So I've put a few authorities there. That's the only law you're going to get, I'm afraid. That's nothing else about the law in these notes at all. And then older children is the other warning sign that I would flag up, because there isn't much point in parents reaching an agreement if their teenager turns around and says, no way am I going to live in Wyoming, why would I want to do that? So if you've got older children and there is a disagreement, particularly a disagreement about what the children think, you are probably going to need, not necessarily a court process, but some process of a neutral evaluation of the children's wishes and feelings before you can realistically reach an agreement that is likely to stick. And then finally, timings and delay. Beware of mediation being used tactically. We've all done it to exhaust the other side, emotionally or financially. Sometimes, especially if you are for the more vulnerable party, whatever type of vulnerability it is, you really do just need to get on an issue. So that's pretty much all I want to say. One final thought, all else aside, one really good reason why mediation is a good idea in any relocation case, whatever the circumstances. I was involved in an appeal last year. I wasn't involved below, thankfully, where an international relocation case had been heard over a week, 5 days. And you'll be thinking, oh, that's good, you know, nice amount of court time. Don't get that very often these days in private law. No. This case got something between 1 and 2.5 hours each day, while the court simultaneously heard a 5-day care case. So morning care, afternoon relocation, sometimes swapping round, a few directions hearings along the way as well, judgment in the care case at 12 noon on the Friday, and in the relocation case at 2:15. We appealed it. Yeah, did you say poor judge? Yeah, I want to say sympathetic to the judge. Poor client. We appealed on, or tried to appeal on grounds of procedural unfairness. How can you hold all of those issues in your head at the same time? How can you do 2 cases simultaneously? And permission to appeal was refused at our oral hearing. So mediation must be a better alternative than that. And for the time being, while the Children's Arbitration Scheme excludes international relocation as an issue, it is pretty much the only alternative to litigation. So another good reason to keep out of the